A very common question that I get from my clients is how do they choose what I'm calling fiduciaries in their estate planning documents? To put it very simply, what fiduciary is going to be your executor, guardian of any minor children that you might have, and a trustee for any trust that you might form by virtue of the estate plan that I put together for you. The first thing we'll talk about is the executor. An executor is quite simply that person who's going to make sure that everything you have listed in your will, any directions, are actually followed well and in the way that you would have wanted them to be followed. So that's someone who's going to liaison with the courts and any attorney that may or may not be involved in the administration of your estate and make sure that your wishes are being fulfilled, quite simply. They're going to have to dot I's and cross T's and really have a facility with dealing with the court and the lawyers in a competent. This is a very different skill set than, say, choosing a guardian for your minor child. That's a very difficult decision, probably a more difficult decision than the executor. The thing to remember is in that stereotypical situation where, a married couple comes to me, they cannot name each other as guardians of their minor children because the only time that that's going to kick in is, assuming that these children are both biologically and legally the parents' children. So for instance, a stepchild is going to have different considerations around their guardianship, who they can name as guardians, than someone who's just biologically related to both parents. So a guardian for your child is someone who literally will will take care of your child, will live in their house, and parenting decisions and parenting philosophies will be implemented for that child based on the guardian's philosophies. So the big thing to consider is what's your knee-jerk is where I start. It's your knee-jerk reaction to who would you want to have take care of your kids. 9 times out of 10, that's who you should go with. And that's going to probably come down to who do you think is going to raise your child the way that you would want them to be raised if you were no longer able to do it yourself. And so that's going to have everything to do with the small decisions that these people will make on a daily basis, and also the large decisions and the way that they're going to guide your child if you're not able to do it yourself. But other more concrete ideas of what you should consider are also geography. Is this a situation where you really think it's a deal breaker if the child's not going to be able to attend the same school? They're going to have to move away from the state or the school district and all of their friends and everyone they've known. This is something that you should consider, although it shouldn't be the only thing that you consider. Another factor is going to be the age of the guardians. Do you want to go with, say, your parents who are going to be a little bit older, obviously maybe a little more than a little bit older, or are you going to want to go with a peer of yours? Or maybe if you're an older parent yourself, maybe you want to go with someone who's younger. You're going to want to consider the specific people that you're considering naming as the guardian, and it's so idiosyncratic and nuanced that it's really hard to make really general assertions. But these are some of the considerations that you should make. The final typical fiduciary that you're going to name in your will is going to be a trustee. Usually I set up a trust for any minor child that may inherit. And the trustee is basically going to be that person who manages the finances and the assets that you're leaving to your children in trust. So this may or may not be the same person as your guardian. You can easily imagine a scenario where your guardian is amazing with your children, they really understand them, that's who you want to raise them, but maybe they're not great with money. And you want someone who's going to administer the trust and make sure that those assets are being taken care of and not only invested well, but also distributed in the right manner to your children. So those are the 3 major fiduciaries: executor, guardian, and trustee. The guardian trustee, just to recap, cannot be your current spouse because the only way for those they cannot be the other biological parent of your children, because that person's the only reason those provisions will kick in is if both of you have died. But the executor, you can name your spouse.